Good afternoon, everyone. My name is Amanda Witt. I am a partner at Kilpatrick Townsend and now the chair of the Privacy and Technology Law section of the Georgia Bar as we start our new bar year, and this is a great way to kick it off. So we have a great program for you today, but we are also planning a number of CLEs for this year that will touch on state privacy law updates and also children's privacy and AI, and we're looking to do a number of joint sessions with other sections where we'll do some social engagements and community outreach and also outreach to law students. So if you're not a member of the section, please consider joining, and we really hope to see you at some of these events. And with that, I'll kick it off to Tony to introduce this great panel.
Fabulous. Hi, everyone. My name is Tony Igbenova. I'm an associate at Baker Hostetler doing all things privacy governance, both international and domestic, as well as biometric compliance and advertising and tracking technology compliance. I'm very happy to moderate today's panel, and I'll allow our panelists to introduce ourselves, starting off with Stuart.
Hi, everyone. I'm Stuart Bohan, and I currently am a director of business and legal affairs at the BBC in Washington, D.C. I support global ad sales and product build. So dealing with a lot of issues around advertising, tracking, work a lot with our privacy team. And prior to this role, I was with Turner / Warner Media / Warner Brothers Discovery for almost 8 years. I'm doing similar work and then also working closely with our privacy team there. So looking forward to speaking with you all.
And Rosemary, we'll go ahead with you next.
All right. Hi, everyone. I'm Rosemary Cooperberg. I'm Associate General Counsel for Privacy at Demandbase, which is a smarter go-to-market company for B2B brands. And ad tech is what I live and breathe. So happy to be here. This is going to be fun.
And last but not least, Scott.
Good afternoon, everyone. I'm Scott Griffin. I'm Assistant General Counsel at PBS. I moved into PBS handling mostly our IP and technology transactions work. And then as time has progressed, I've been working with our digital and marketing groups and handling more and more privacy issues, and including ad tech, because I think everyone that's a technology lawyer these days has to deal with privacy in some way, shape, or form. Before that, I was at Aflac in Georgia, and PBS, sorry, is also based just outside of DC, and also did a turn at Kilpatrick. So.
Fabulous. Thanks to our panelists for that awesome introduction. We can jump to the next slide. So just flagging to you all that today's panel, the goal is to be very conversational. We're not reading off of the slides. We're here to have an engaging conversation as it relates to the state laws and the Video Privacy Protection Act. But here you see we have a bird's-eye view of the EU and the US landscape as it relates to advertising and tracking technologies. As mentioned, we'll discuss a few of these more in depth, including the VPPA and the US state laws. So we can hop to the next slide. Stuart, can you provide us some context for those who are not aware and background regarding what advertising and tracking technologies consist of and how they are deployed? Let's start with the basics before we jump into the meat and potatoes.
Sounds good. So these terms may be familiar to a lot of you if you've been on the internet in the last decade plus, particularly cookies. But cookies, pixels, tags, we'll just talk through a little bit of what each of these generally entails. So cookies at its most basic element, cookies are small data elements that a website can set on your computer that holds information about you as a user. So if you visit CNN.com, a cookie can be placed on your computer that shows that you visited that website and potentially other information about what you looked at on that website, where you went, where you came from, any sort of information that might be valuable to a publisher or an advertiser who could place a cookie. These cookies can be placed, as I just referenced, either by the publisher, which would be on the publisher's site. So for CNN, if they place a cookie, that's called a first-party cookie. It's information related to action on their site, or cookies can be placed by third parties, which may be an advertiser. So if an advertiser on CNN places a cookie on a user's hard drive, then that would be a third-party cookie and would track different information. Pixels, which is the second bucket here. Pixels are kind of the mechanism by which information is transmitted from a website to an external server. So the cookie itself sits on a device, but the pixel allows communication of information, passage of cookies, placement of cookies to occur between an external server and a website that a user is visiting. So they're interrelated, and I guess you can think of the pixel as kind of like a way station or a toll station, but instead of paying, a cookie is placed to get access to the website. And then lastly, tags. So in this slide, this is really meta tags. You may hear tags generally refer to pixels or cookies or any piece of advertising technology, but here meta tags are actually sort of just descriptors or keywords that live in the code of a website that like a search engine is able to read to make sure that search engine optimization occurs, that the right results are showing up for a website. So if you search for news and current events, that the results that you get based on tag reading, meta tag reading, are websites that relate to news and current events. So again, that's a very, very basic overview, but these are sort of the building blocks of how tracking technologies work today. And just again, these kind of run the gamut of usage for any number of things, such as making sure that you, as a user, that your login information is remembered, that you have a shopping cart that can actually work, and remember that you're holding items in that cart, or information can be collected to target advertisements to you as you kind of work across the web. So hopefully that's a helpful reminder and refresher of what these are.
Thanks for that context, Stuart. By the way, your microphone seems to be going in and out a little bit, especially towards the ending of your sentences.
Okay, I will move closer to the computer and move left. That should.
All righty. All right, so now that we have some context regarding what these technologies are and how they're deployed at a very high level, Rosemary, how have organizations enjoyed the benefits of these technologies? At a high level, what differences have companies seen since the deployment of these technologies?
Sure, yeah. So it is sort of like, and I'm not an expert in the history of advertising, but all of these types of trackers work to make advertising more specific and more relevant to specific users. So I saw a study, it's from 2020, so I think this number is probably up now because of everything that's happened, but that 80% of advertisers rely on third-party cookies, and that's just when we're talking about cookies. So it's sort of like, in the olden days when you would place a newspaper ad, right? Like you reach the audience that happens to subscribe to the newspaper, which is probably from a specific locality, or like a billboard, right? You reach the people who drive by and who are looking out their window at the time, right? The more specific you can get to your audience, the more relevant all of this becomes, and the more likely a user is to click on the ad, pay attention to the ad, look at what's being suggested for them. And so as an advertiser, the more relevant you can make that, the more likely it is that your ad is going to help your business because you're going to reach the intended audience. So with some of this tracking technology, yes, you can reach a more specific audience. Like a couple of weeks ago, got an ad, which I normally don't pay attention to. So I don't know what I was doing on this day, but there was an ad for a specific kind of planner that works best for people with ADHD like I have, right? I never knew that thing existed. It has now changed my life. Like I'm super happy that I saw that ad because it was relevant to me and it was something that resonated, right? Whereas if I see an online ad for fishing gear or something like that, that is not that is not for me. I'm not going to pay attention to that, right? So whoever paid to put that ad up that money is wasted, right? So everybody who is advertising, and advertising is how the internet works, like that's sort of the foundation, right, of all of this. Everyone who's advertising wants to make sure they reach a relevant audience. And so these types of technologies help them do that. So obviously everybody wants to make sure that people can exercise their privacy rights. And if they don't want specific targeted advertising or profiling or whatever, that they can opt out of that and have a choice. But I do think it's important to note that you cannot, as far as I know, and y'all can correct me if I'm wrong, but you can't opt out of digital advertising completely. Like that's not a thing you can do. So when you opt out of targeted advertising or some of these other things, what you're saying is show me whatever ads you want to, just don't target it to me. So that means that it's probably not going to resonate as much with a user. So yes, we want to make sure that all of these trackers are used responsibly and that folks can exercise their rights and all of that. But it does help keep the internet running, the more effective advertising can be, because a lot of the content that's out there for free to users is paid for by ads. So we want that, well, the internet wants that business to keep going.
That's some awesome information. I also do not receive ads related to fishing gear. So if you do, please drop it in the chat so we can know that the ad tech is truly working. But Stuart and Scott, I wanted to open your thoughts to the benefits that organization has seen, whether you have anything extra to add to what Rosemary has given us.
Sure, I can go ahead and start. I mean, and I'm speaking on, I want to say I'm not speaking on behalf of PBS here at all. I'm speaking on behalf of, I might use some examples from the type of business that we're in, but I'm not speaking on our behalf. I'm speaking from personal knowledge. I'm not, and especially as we get into some of the litigation issues, I'm not going to go into anything that would be talking about a position that we were taking, but just my experience and understanding of how some of these are working. But for instance, digital, I think we have all seen in our experiences on the internet and started getting creeped out early on when we've all had the experience of, oh, I've gone and searched for a hotel in a specific place or a specific product or a specific flight, whatever it may be, and then come back in another browser window or come back the next day and you're being fed ads for those particular whether it's applied to hotel brand products, et cetera. And all of us initially reacted as, oh, that's a little bit weird. So, it does have, to Rosemary's point, that's how the internet works. And it's like, and there's things that are companies that are for their benefit, for their own call to sell. But also trying to pair things with you that spark your interest or that have your interest. And so from a video providers or a video provider standpoint, some of that information and some of those ads and ad tracking may be used for saying, hey, if you watched this particular program over here, you might like this. If you watched, to pick on Stuart a little bit, if you're watching BBC America on your computer on a Saturday and you're watching all the nature programs, then you might get one that, hey, this new thing with David Attenborough is coming out next time. And so, and the benefits are not just to, I would say the benefits are not just to businesses and not just to profit earning businesses, they're also to the consumers as well, in terms of, instead of you fumbling around the internet, which is obviously a very broad and diverse place, looking for something that is very specific to your interest, using that information might be able to feed you things that you're interested in.
Love that. And general flag, we are all not speaking for our organizations. I was supposed to say that at the top, excuse me. Stuart, any final thoughts on this area?
Yeah, no, Rosemary and Scott made great points. I think the content recommendation point is a really good thought about, how are these tracking technologies being used in ways that aren't just for targeted advertising, that are really useful to a brand or a publisher, things like measurement or just even research of audience that doesn't result in a targeted ad to a user. That this technology is critical for those functions as well. So it benefits both in the targeted advertising space, and then lots of other ways that companies need to collect and use data to inform their products.
Right. And Rosemary, at the heart of it, I think you made a great point, because if you opt out of targeted advertising, which we will jump into later, you're still going to get ads. So why not see what you want to see versus seeing anything? I mean, that's debatable. We can go back and forth on that all day long. But let's switch gears to recent litigation trends, because I know that's why most folks are on here. VPPA, you see here, you have a slide full of headlines. Okay, Scott, how did this law come about in the first place? I'm aware that it has an interesting history. And then
it does.
I have a double question here.
Sorry.
And then how did this law go from protecting content and viewership to now potentially being applicable to tracking technologies? A mouthful there. How did this originate, and how did it go from video viewership to now online tracking technologies?
So this law, the VPPA, is the Video Privacy Protection Act, and it was actually passed by Congress back in 1988. So this is well before, well, I think probably the internet was probably a DARPA project at that point. And some universities were using it, but certainly before the internet as we know it today existed. If anyone remembers the confirmation hearings for Judge Robert Bork, he was a judge, I believe, on the DC Circuit at the time. He was nominated by the Supreme Court, or for the Supreme Court, excuse me. And his nomination was a bit contentious. During the nomination process, a journalist in the DC area who knew where he lived went to his local video store and managed to get literally a list of, and this was back when Blockbusters existed, for those on the call that might be, that remember Blockbusters. The journalist went to like his local Blockbuster and managed to get a list of all of the videos that the judge and his family had checked out, which I believe some of them were used and brought up, or at least entered into evidence during his Senate confirmation hearing. Judge Bork eventually did not make it onto the Supreme Court, but the Senate at the time thought, and the Congress at the time thought, this is not something that should really be, someone should be able to just walk into a video store and see everything that you've rented. So the Video Privacy Protection Act came about, which limits, it says that, someone has to, or a user or someone that is viewing a particular video has to approve information about the videos that you see being disclosed to a third party. So that's where it came from. But like all good laws, especially, and I'll kind of refer back to some of my IP friends here and people that have done patent litigation in the past, like a lot of laws and things that were applying to technology that were decades old. I will be very honest, I am taking a defense position in this discussion more than a more balanced legal position. So I just want to be very clear about that. But some intrepid plaintiffs lawyers have realized that elements of that case can now be, are trying to, and have brought a number of cases. I think it's 165 plus at last count, at least that was the last number that I remember hearing, of cases alleging that the Facebook pixel, and I'm going to call it the Facebook pixel instead of the metapixel. I think a lot of these articles are saying metapixel, but not to confuse Meta, the company, with meta tags that Stuart was talking about. I'm going to use Facebook pixel for specificity in this respect. Is a common pixel that I think is you could say ubiquitous. It's across websites of all types of industries, on that different industries and different websites place on their website. And it's a piece of code that returns certain information to Facebook. and Facebook ad tracking, and Facebook offers a service to determine how those, what ads are successful and what people are doing on their site. So the legislation itself states that, again, you have to have a user must give the okay and must give assent for a party that has their viewing information to then provide that information to another party. So what does that mean now? And what does that have to do with ad tech? Well, the Facebook pixel is a pixel, as we said, that tracks, and then it tracks somebody, if a person is logged on to Facebook and then visits another site, then the Facebook pixel at that point is a cookie on their computer, but it's also it's a tag that's living there. The Facebook pixel will return to Facebook the user's Facebook ID as well as the URL or some other technical information or some other code that states where that user was in their journey across the internet, and that they went to a particular page. And these are I will make clear, these are the plaintiff's allegations. And the plaintiff's allegations in these cases is that sending, let me back up for just 1 minute. The VPPA itself, in order to create a case for violation of the VPPA, you have to have a couple elements. So let's get into a legal bit about it. First, the defendant must be a video services provider. Second, the plaintiff must be a consumer of those services. And now we're getting into where courts define these things differently depending on where you are. So the 11th Circuit versus California versus the 2nd Circuit in New York versus the 5th Circuit in Texas, they vary in terms of what they consider a consumer. They might be a subscriber. They might just have created an account on your website. They might get newsletters, or they might be a subscriber to a particular service. Being a consumer of those services does not require a payment of money. It's just that you have an ongoing, the courts are holding that it's just the consumer has an ongoing, or the viewer has an ongoing relationship with the entity that would become the defendant. The defendant has to knowingly disclose personally identifiable information and their video viewing information without consent. So going back to the Facebook pixel example and why this has become such a vast array of cases, and these are in courts across the country, there are class actions as well. Whenever the Facebook pixel is on somebody's website or on an entity's website, I, viewer or internet user, have logged into Facebook on my Facebook account. I go to that website. That website has video on that page. And depending on what the URL is or what the other identifying characteristics of that page are from a metadata perspective or just from the description of the web page, I view that video. Facebook is sending back, or excuse me, the pixel is sending back to Facebook my Facebook ID and the fact that I viewed that video. Plaintiffs are alleging that sending back the Facebook ID to Facebook is sending personal information, and sending, say, the URL of a particular video, say, Planet Earth Season 1, Episode 3. Sorry, I'm picking on BBC Today, Stuart. Then plaintiffs are alleging that is enough to get and if it's done without a specific VPPA consent on a site, then that is enough to trigger the VPPA. And then further allegations are that it's a knowing transmission because the defendant website placed a pixel on its website knowing what would happen. Excuse me. And if it's somebody that has some sort of account with that particular entity or that site, then you have an ongoing consumer relationship. And again, these cases are all over the country and courts all over the country at the district court level, mostly. None of them have fully made their way through. And there are differences in analysis in these various courts of, is the Facebook ID actually personal identifiable information? Is sending this particular URL of the video that someone has watched to Facebook, is that actually sending video viewing information? Because there's a whole question of, did someone actually click on that video? Did they actually watch it? We don't know. Plaintiffs' attorneys would argue, well, in the way that the VPPA was originally drafted, we got a list of VHS cassettes that someone checked out of or rented from that particular store. We don't know if anybody in the home actually watched it. So you don't need the home, or sorry, you don't need to know if they actually viewed it or not. Defendants obviously would disagree and need some sort of say, hey, you need to actually show that somebody viewed this. There have been defendants that have made arguments about whether this was actually a knowing disclosure. You know, are you assumed as company A to understand what the Facebook pixel does when it's operating and what it's actually sending? Is it actually personal identifiable information if only Facebook can understand what a Facebook ID is? The reason that this is getting, so this raft of litigation actually started with hospitals, and it's across industries. And that's why everybody really needs to worry about it a little bit and understand what's happening with these various pixels and tracking technologies across their websites. Because although it started with Facebook, I think we can probably understand that there's, I think all of us on this call would understand that, you know, that's the first of others. Liability can be pretty significant here, depending on which site you have. The consumers are thinking about statutory damages in $2,500 per violation. So that doesn't sound like that much. But if it's $2,500 per subscriber per video they've clicked on, so if you have 100 million subscribers, or subscribers that with the court, and the courts, as I said, have been pretty loose with what a subscriber could be or a consumer could be. If you've got 100 million consumers or subscribers, and then you've got, say, 50 so 50 different videos on your site that they're watching, and each click on that is sending back, and it's $2,500 per click, then you have an option for punitive damages. You could do the math on that. I don't have my calculator right now. But then you've got then you have potential for punitive damage and recovery of attorney fees. The demands and the ask in these cases are getting into the hundreds of millions and not in the small hundreds of millions of dollars. And so it's an example of, you know, a law that was written for a different type of technology, for something for several decades ago, that's now being used. And then all these cases are now making their way to the courts. Motions to dismiss have been mostly unsuccessful. There have been a handful that have actually been successful. But until these cases really start making their way to the courts and we get some better and some appellate level interpretations of what these different elements of this law mean, I think we can assume that we're just going to see more of them.
Oh man, Scott, that was such a great background, because I know folks had a lot of questions as to how these lawsuits are actually taking effect. What's actually happening? Love that context of videos being on a page, the pixel being on the page, clicking on the video, or potentially not clicking on the video, and information going back to Meta along with that video viewership. And now plaintiffs' attorneys are alleging that the VPPA has been violated or the VPPA is impacted. But we have a lot more to cover in 30 minutes. So with our last couple of minutes focusing on the VPPA, looking at the recent Carroll versus General Mills class action lawsuit, where the court stated that plaintiffs seeking to bring a claim under the VPPA must plead facts demonstrating that the defendant's particular field of endeavor is the delivery of audio-visual materials rather than a small part of their marketing strategies. So in essence, this court is saying that posting videos online that are only incidental to a company's core business is not subject to the VPPA. Very interesting. Do you think this court's opinion could potentially kill all VPPA class actions going forward? Is this the end? Thoughts on that?
I don't think it'll kill everything by a long shot. You know, there are still a lot of us out there who have videos on our sites, and that's the intent of our web business or our business in general. So yeah, and I do think there are probably, now that entertainment and advertising and other businesses in a lot of ways are merged. So if, I mean, this is across industries. Like I said, this started with hospitals, but you know, there are, say, car companies that make short films that are really marketing films. You know, would that fall within there, or is it actually supposed to be entertainment as well? So, you know, I think there are enough gray areas and enough industries that do create creative video content that is meant to be viewed for its own sake, that it wouldn't necessarily be as entertainment, that it wouldn't necessarily say, oh, just because you're a car company, then automatically that kicks you out. But, you know, for, you know, in this example, you know, for, you know, if it's another food company that is showing someone make one of their recipes or something like that, and it can be shown that this was just purely for demonstration or marketing purposes rather than for entertainment purposes on its own. I mean, hopefully it will at least curb, but I would say this is in California, and these are all over the country. So New York, Georgia, Florida, Texas, you know, every district court in every state could actually have a different take on that. So again, we need it until it really works its way through the appellate levels. It's hard to tell.
Very
And
interesting.
if I could just jump in for anyone who's out there and has business clients, there are a couple things I've heard about that you can try on your website to make you less likely a target for these suits. And Scott, obviously jump in if you disagree here, but there are a couple things. The VPPA, as you said, requires the user's assent to send this information, right? So getting consent from the user would work. There's also a theory that I have heard that if the video's on your website in the URL, if it doesn't say the name of the video, it doesn't say Planet Earth episode, whatever, it's just like randomized, that might be a way to protect yourself as well. So there's a couple of suggestions, who knows?
Oh, Stuart, go ahead.
Oh no, I was just gonna add, and just conducting really thorough due diligence of vendors that you use and partner, really asking very specific questions tailored to these data elements and what happens to them once they are collected or passed, and then having any sort of contractual obligations around that potentially, right? The things that I think in publishing we probably thought about for a long time, but that maybe other areas, you know, are starting to think about too, given Scott has said.
And if I may, I would add one more thing. There is also a defense. I mean, and I second what Rosemary said. I don't want to be redundant and repetitive there, but there is also a defense that had some success. I can't remember the name of the case off the top of my head, but there's a First Amendment defense here. That if the content is journalistic or a news organization and it's happening, then you've got a First Amendment defense as well in those, you know, in those circumstances, those limited circumstances. So again, it's as Stuart just, it's a matter of really having a very clear understanding of what your content is, how it's labeled in the back, you know, whether it's in the background or in the URL or whatever, and then what information is going where.
Awesome. And just another 2 minutes on VPPA. I was having a conversation with a partner yesterday about this, and we talked about gaining consent, and we just talked about how crazy it would be if you have to, per VPPA, you have to ask for consent for each video. So we're already sick of cookie banners. Can you imagine consent per each video on a web page? Item number 2, how will folks revoke consent? So yeah, we definitely have a lot of unanswered questions.
But maybe you can build it into the cookie banner that people are also annoyed with already.
Oh,
So it's
Lord.
not 2 levels of annoyance.
More cookie
saying.
banners.
That sounds
Oh.
like a segue to the state law.
But we do have one quick question to cover. Someone asks, what are the grounds for the motion to dismiss?
That's a good question. They vary. Speaking anecdotally, I will say, obviously in the General Mills case, we're not a video services provider. It could be on any of those. Is it an unknown plaintiff to you? Like, do you have an ongoing relationship with that plaintiff? If that plaintiff has, as that plaintiff is a subscriber to your business in some way, have they created an account? Do you have information about that plaintiff? Or is it just someone that came to your website and clicked on a video? One of the elements is that it's a consumer, and in some courts are saying that has to be some kind of ongoing relationship to establish that. I would say, based on what I've seen, knowing disclosure is iffy at this point, and it's certainly not right for a motion to dismiss that's going to require more discovery. Same with personally identifiable information, and their viewing content. So I would say that across these cases, probably all of these have been tried as affirmative, that we don't meet this particular element of the claim as part of the motion to dismiss. But it really, I think that's a fact-based question based on your circumstance and your relationship to the plaintiff, how your site works, et cetera. Because there's a lot of nuance there in the background, and as Stuart mentioned earlier, it's getting very, very clear and in the weeds about those specifics.
Awesome, thank you for that. All right, so let's shift to state privacy law compliance. As we all know, this is a constantly shifting landscape, yet there are business implications that relate to advertising and tracking technologies. So Rosemary, can you provide us with context around what these state law requirements are and whether they vary significantly?
Yeah, for sure. So deep breath, everybody. There are now 13 state laws. As you can see, there's 2 on here that have not yet been signed by the governor, but a few months ago, I think we were at 4. So states are on it with privacy laws, and great. Now, that being said, none of these 13 laws say the same thing in the same way. So there's sort of clumps of groups of states that are similar in some ways, but it's not like straight down the line, Virginia and Utah are the same. Like, it'll be similar in some ways, but maybe not with respect to tracking technology. So it's important to know which business, where your business is in business, right? That's just general corporate governance, in order to figure out which of these laws apply. And I will say one of the biggest differences is that California is the only state that expressly includes business information or information about employees. So most of the other ones have some sort of exception for B2B data, saying it's not covered, and that there's some form of wording which is different in a lot of places, but it says these laws cover a consumer except in a business, acting solely in a business or employment context, right? So You have to know, are you B2C or B2B? If you're B2B, then you have to still obviously pay attention to California. And you also have to think about if you have information about, say, somebody's mobile device. Do you think that mobile device is used solely for business or employment purposes, or is it possible that it's also used for consumer purposes, in which case you've got to figure out how to handle these. So we've got 5 different opt-out rights here, and the majority of them are opt-out, not opt-in, which we'll talk about in a little bit. Selling personal information. So that's in a lot of these. We've got sharing personal information, which I believe is only in California, and it's only sharing for the purpose of cross-contextual behavioral advertising. So it's not just any sharing of personal information, but there's that one. We've got opted out of targeted advertising, which we talked about a little bit earlier. We also have this requirement to honor universal opt-out signals. So there are being developed some signals that you as a user can set in your browser, like the global privacy control that says, I don't want to be tracked. And the states that have this requirement, I should only have to set that signal once in my browser and never again. So it's not, I get a cookie banner on every page and then I have to like accept or deny or whatever. The idea of these universal opt-out signals is that the user sets it once. So those are still quite new, I think, and so we'll see how those go. But as you can see, there are more than 0 states that now require that. And then the last one is profiling. And it's also important to notice that profiling in this context means profiling with a significant legal impact on the person, or profiling in a way that impacts the person's legal rights. And again, the wording in the different statutes is different, but it's not just any profile for any reason, right? So it's profiling that has a specific and significant legal impact on the user. So the good news maybe is that none of the states have all 5 of these. So that's something, right? I'm trying to find something good. But a lot of these states, I mean, they all have at least one. And so businesses who are operating websites or apps or, anywhere on the internet needs to pay attention to this so they can figure out what's going on. And I will say there are some similarities. Again, some of the rights are written in the same way. Some other similarities, there are a lot of these states that talk about the attorney general in that state enforcing it, right? And some of them have a cure period first. So like someone wants to complain about a specific website, they do that. The business then has 30 days or 45 days or whatever to fix whatever the person is complaining about before the attorney general can do things. So that is present in, I think, 5 of these, and some of those have a sunset period. So there's a cure period right now, but it's going to go away in a couple of years. So also keep in mind, not all of these are effective yet. We have until, I think, January of 2026 before the most recent one takes effect. And so we've got a little bit of time, right? And it, again, differs by state to get our stuff together, but it's kind of a lot. And then another distinction, there are some of these that have a private right of action. So just like the VPPA with statutory damages, there are some of these laws that have similar cause of action for an individual. So that is going to be interesting as well. Good times, right? We love this.
Nice. And Stuart, I know during our prep calls, you had provided some options and mechanisms for opt-outs. So if we have any counsels on the call that, didn't have to comply with any of the prior, but now have to comply with some of the new ones, and they're serving the opt-out mechanism options, what could you advise them regarding the options that they have to prevent consumers with an effective method to opt out of such processings?
Yeah, absolutely. So if you look at the footer of any website that has already been operating in these jurisdictions, or particularly California, you should be able to start getting a sense of what some of these mechanisms are, to affect opt-out. And I guess one thing that is nice about all of these are all opt-out frameworks. None of them are opt-in frameworks like the GDPR. So at least the mechanisms that are currently in place in the US should continue to work. So one option that you will see out of the original sort of CCPA wording and now amended is at the bottom of the website that maybe a do not sell my personal information or do not sell or share. That's a required option, barring an exception that I'll talk about in a second, or you can have a unified link on the bottom of your website that says your privacy choices, and that opens up the ability to restrict selling or sharing your personal information. That's something that you'll see. There are traditional sort of privacy consent management platforms for companies like the BBC based in the UK. We've been subject to the GDPR for a long time, and so we have a very robust consent management platform that identifies all different types of cookies that can be consented or non-consented. And then, as Rosemary mentioned, there's the GPC, the Global Privacy Control, that California, Colorado say that as a website you have to recognize the signals, but they don't mandate browsers implement the signals. So I think that's to her point about we'll see where those go. Right now, there's only, I believe, Firefox, Brave, and DuckDuckGo are the only browsers that have a GPC tool. And then there's 3 other add-ons, but in any event, that's another option where, as she explained, a user can set sort of a do not track signal at the browser level, and then that signal is passed to every website that the user visits. So those are sort of the mechanisms that you will see most often as options that are.
Awesome. Before we jump into questions, last question for our panelists. So these laws, simply put, restrict the use of third-party data or potentially combining third-party data with first-party data for retargeting, especially as more consumers exercise their rights to opt out. So is it reasonable to say that companies may eventually move away from relying on third parties for targeted advertising? Am I revisiting that whole kill the cookie conversation? I'm not saying kill the cookie, please. But I'm just saying, with all these restrictions that are taking place and the burdens of compliance, will organizations continue to rely on third parties? Will organizations start to invest in mechanisms to build out their first party data?
I have thoughts. So I think where we sit right now is no one has really come up with an alternative, right? So now that companies have been using third-party cookies or, some of these technologies, they know it's possible. And great, if we shut those down, how do we get the same business results without that, right? So I think, and this is hard because there are a few big players who sort of everyone is waiting to see what they're going to do, because if a certain company decides to do it one way, like other websites might not work if they don't do it the same way as some of the big guys, right? So it's sort of a vacuum, I guess. Like, yeah, maybe these specific types of trackers will go away, but I don't know that anyone has come up with a good answer for what will replace them, right? And so we have to, it's sort of a waiting game. I don't know, maybe y'all have heard of replacement ideas that I don't know of, but like we're sort of just all waiting.
Yeah, and I mean, to that point, getting a lot of first-party data is really challenging for most parties in this ecosystem. Even some of the biggest media companies and publishers can have a really hard time getting good first-party data at a scale that is really as useful as companies have had in the past. So I mean, certainly there's ways to get more if you add registration to your website or if you do more surveys and polls, but again, to Rosemary's point, that's going to get you so far, but it's not going to get you to the level we've had before. And so otherwise, no, I agree with what you said.
Yeah, I would agree with all that's been said. I would also note, just if I'm going to take a small step back into the state law issue, if any of you on the call are also, or if your company is a nonprofit, not all of these laws, I just want to make that point, not all of these laws will apply to you. That also may be changing. And so it's going to get, it's going to get fun for those of us that or it's already fun for those of us. It's going to get more fun for those of us that nonprofits. If that was something that you kind of were thinking about in years past. But anyway, now I would echo that, and I kind of go back around to the point that I said before. I think also I think there's a lot of focus on privacy, and there are a lot of in the conversation. And some of the bigger players out there and misuse of data and where is this data going and that sort of thing. Well, also think about which data you and certain companies, especially with the folks that have third-party data that have conglomerated third-party data and have all this data about you that other companies can use to make determinations about where to target advertising is one thing. But I will say, and I'm speaking just from my seat, I'm not saying anything on behalf of PBS, but some of that first party data and some of that data is also used to the consumer's benefit and to offer you the content that you want to see, or to not offer you other content that you don't want to see, and that kind of thing. So, and there have, if a consumer says, I want to, I don't want to give you this data, or I want to turn this off, and I don't want to share this data, or whatever that mechanism is. I mean, even GDPR recognizes that some of that data needs to be available for the company to provide the service that the consumer is asking for. And so, there have been consumers that, okay, we'll turn off this data. Well, we can't offer you this. Like, this is the only way that we can actually offer you the only way that we can deliver you this service. So, I think, is there an alternative right now? No, but I also think there might be a point, and this is just me speculating, there might be a point where consumers start to get okay and less concerned than they are now, because there's so much conversation about it, but get to the point of, oh, I'm not getting this cool stuff that I used to get anymore because I've opted out of these particular things, opted out of these particular cookies, or opted out of these particular things. And when your journey across the web, which I think we can all agree is not going away, starts getting more impacted, consumers aren't getting the services that they used to want to, and they say, well, then you need to opt in over here. That may kind of at least take a little bit of the heat out of the conversation a little bit.
Awesome. Thank you so much to our speakers. I had a great time. I mean, all the points covered, and so much to learn and so much to look forward to as well in these areas. I would love to open up the floor these last 6 minutes that we have, sorry. To our participants, any thoughts or questions that you all have?
Everyone is running away to hide in a hole because it's too hard.
They're like, we have no questions on this. This is out of our hands. Well, okay, well, while we wait for questions to come, since we still have a couple more minutes, I do have a few more questions. All righty. Would you consider these state privacy law measures effective for limiting the burden of targeted advertising, Scott?
Yeah, the burden on whom? I would say, I mean, I think I tend to agree that clarity is good, and the clarity that it offers, that they offer to companies and consumers is good. I think that the differentiation between them that Rosemary spoke about could be a bit more burdensome in terms of, okay, what do I do? I have to do over here and what do I have to do over here? And I don't know if it really lessens an overall burden if you have to say, okay, well, let's just pick the highest standard that's out there to make sure that we meet, it'll be easier just to go for what are the most restrictive standards and what's the highest one that's out there. So we know we comply with everybody. That I've heard that discussion a bit as well, in the absence of a federal, a more overarching national or federal law, which could also help with, those of us that, or for those of us or companies that have, cross-border transactions and have to deal with GDPR and the differences there. So, I think there's some clarity, but I don't know if it with them all being with them being different, and with the number of them out there, I don't know if I can say it necessarily fully decreases the burden. And I think it might increase the confusion to the consumer a little bit, and because it's, they'll hear something on the news that such and such a state did this, and they'll say, well, my state's not doing that, or my state does something different. So it's.
All righty, and we do have go ahead, Stuart, before I jump into the question.
You're good, go ahead.
All righty. So we have a question for any suggestions for compliance or technical consultants who have a good grip on managing technical opt-outs, including automatic opt-out options. This may be a hard question.
I think I am not in a position to recommend one tool or another, but I do think it's important to look at your consent management platform, whatever you currently use, and make sure it can keep up with the new things. Like, you may have set it up for GDPR in 2018 and then no one really thought about it again, and maybe it talks to the global privacy control and maybe it doesn't. So if you're already using one, start with that and make sure that it can be updated or configured to include some of these new opt-out rights, so you only have to use one tool. If you don't have one, the IAPP, which is the International Association of Privacy Professionals, has a page about privacy technology and different vendors and consultants and whatever that do certain things. And so that could be a good place to start.
Fabulous. And last question with our last couple of minutes. What are some pain points that companies have seen or experienced in implementing these measures to comply with the state law requirements?
Come on, it's all fun and games. There's no pain. No, I will say most companies, I think, are really trying to do the right thing. It's just so confusing. And like you said, there are some talks about like, well, just pick the strictest standard and go with that. But then if you suddenly have almost zero traffic on your webpage because you did it that way, like, is that really the right option? Or do we want to try to dig in a little bit more and whatever? So it's really hard to make like blanket decisions like that, I would say, and decide, oh, we're going to go with the strictest, or, oh, we're going to go with the least strict. But, the law that still exists, that's the least strict. Like, you can do that, and that might work for your clients and your business, but you have to really know the trade-offs in order to make an educated decision.
Yeah, I would say, and also, like, what information do you have, and that actually creates a risk from a state law or regulatory standpoint? That's kind of the first step in terms of, and I would say probably the burden is really figuring out where all your data is and what it is and what you're doing with it, and then like kind of looking at it against each one of those laws.
And I still think to Scott's earlier point, like, then how you present that to users is like an additional confusing step that can create some real difficulties for users. yeah, it's and you can really, it's fascinating if you just go to the bottom of every website and look. It's different across the board, so you can tell like every company of every kind is kind of struggling with this exact sort of piece right now too.
I second that thought, definitely in advising clients too. There's so many different ways that you can do it. Really interesting. Well, we are at time and I do not want to take anyone's time more than what's recommended or what's needed. Thank you all so much for joining today's panel, and thank you to our panelists for this awesome content. Hope you all join us next month when we have the event go out, but we intend on having a state law roundup and a healthcare deep dive. So yeah, we'll see y'all next time. Have a great one.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.